I have just written a message for you that I hope that all is well. You are able to hear me, you are able to see me, and you are able to feel my presence in your room, at your place where you are sitting. The vibrance, the resonance should reach to you. I'll try my level best, but of course, this is online class, so the distance may be huge, but we'll try to fill up this distance, don't worry. And I will look after all your concerns and queries. That's my promise. That's my promise at the outset. If you feel sometimes that it is not taken care, you just tell me, you just let me know after the class. I will look into the matter, I will resolve it immediately. That competence we have been training students for so many years, and we are proud and privileged that our students have got the highest marks in law optional. One of our students got better marks than another student of ours itself from NLU. So the college, it may help you. Many people will say, I am this, I am that, and I do not need coaching. I will not say anything. You have immense potential. Anybody has immense potential. They can do wonders. But coaching is a facilitator. Our role is of facilitator. We can facilitate. It is your energy, it is your effort, it is your endeavor. With our experience and excellence, that we can create wonders even better and sooner. So many people will say many things, but I am saying law or any optional for that matter, I am not comparing this subject with other subject. I will do little bit for your clarity. But any subject is subject of 200 questions. If you see the subject like this, the 200 questions. So if I do 3 questions a day, 70 days. If you do 1 question a day, 200 days. If you see 2 questions a day, this is 100 days. So what I am recommending, what I am saying, that to make your task easier, better, you have to adopt this question approach. We'll do this. Basically, in your subject, I tell you, the main papers, just for your clarity, because it is first class, so everybody should understand. Constitution, international law, similarly, IPC is there, contract is there, tort is there, main papers, and then small papers like partnership, sales of goods, negotiable instrument. Those who are not able to understand it right now, they'll understand partnership is a subject, partnership act. Sales of goods act is for sales of goods. When you sell the goods, then this law applies. Negotiable instrument relates to checks, etc. Then arbitration and conciliation act, consumer protection. These are very small acts. And then of course, contemporary legal development. So now this 1, 2, 3, 4. These are 4, let us say 5. This is also smaller, it is in between. These are 2 papers which are little lengthier, this may be, but contract is little lesser, tort is even lesser, and these are very small papers. But yes, if you do not know how to study, you can make it very difficult, you can make it very lengthy. You can take enough time to prepare these papers, but will not take much time, I tell you. Constitution and admin law is 1/4 syllabus, international law is 1/4 syllabus. IPC and tort is, you can say 1/4 syllabus, and then contract and these other things are 1/4 syllabus. So similarly, we'll divide time here and we'll be able to complete the course within the stipulated time. There is no doubt. Now, this subject doesn't require any law background. I do not think that there is any requirement of law background. No, not at all. Anybody can study this subject. That will be clear to you. आप ऐसे भी constitution, you are required to read constitution. So if you can read constitution, why not IPC and contract? I don't know. Are you getting the point? So that is not at all an issue. This is all created. Now you are a competent person. You can do wonders. You can learn any subject, many subject. Nothing on this earth is beyond your learning. You can learn anything. Anybody can learn anything. Only there is need of commitment, discipline. Now, before I go into this, I will recommend you certain things. First, you should not deviate and divert much. I recommend to all my students these days that you have to keep in mind DRS system. Discipline, routine, and system. You be disciplined, you have a routine, and you create a system. Discipline is a word which has been used in this context, that while reading we have to maintain the discipline. Now, what kind of discipline we are required to maintain? Let me tell you. Suppose I am going to study this constitution, and in constitution I have picked up the topic of preamble. Now I am teaching you preamble with all perspective, but not in the perspective of IS examination. See, on preamble somebody can write a book, somebody can do research, somebody can teach with polity aspects, somebody can teach for objective examination, and somebody can teach for judicial services examination, and somebody has to teach for IS examination. This all teaching is different. Though the core of subject will remain same, I do agree. But teaching aspects, the teaching pattern will be different. What pattern we are required to adopt? We'll see all the questions of preamble asked till date. I have got questions of almost now 45 years with me, from 75. So 45 years questions will give you enough guidance. It is barely 4 years younger than me. I am 4 years elder. So that many questions will give you enough idea what to do in this topic of preamble. If you start reading preamble, you can start reading R.C. Lahoti and preamble. He has written a book. That is not the way. So we have to maintain discipline. Discipline not only here, I tell you, my dear friend, you are all are aspirants of IS examination. I tell you, you have to maintain discipline even in this sense, that you should not waste your time and you should start your preparation as early as possible, and that too in definite direction. Just reading, attending coaching classes is not going to do. I remember one of my student who is from non-law background. He was engineer working in Gurgaon, and he is from Modi Nagar. He is additional DCP here in Delhi, because he is not very senior right now. He is an IPS officer. So I asked him once, and I asked his wife also, because they came for, I requested them to come for some kind of session in my institute. So I asked basically his wife that what kind of problem do you see with the students here in Old Rajendra Nagar or Karol Bagh or in IS examination. So she was very candid in her statement, and she said, I see student hopping from one shop to another and buying all kind of materials. I tell you, this greed of material breeds failure. Don't run his helter skelter. Don't run for books. Don't run for so many things. It is not advisable at all. No, I said discipline in material, discipline in class, attend class daily, discipline in answering question, discipline in learning, discipline in reading, discipline in maintaining some kind of routine. So routine is very important in the sense that you have a time limit, timeline. I have to finish this constitution in next 20 to 25 days. It should not cross beyond that. It should not happen that you are reading constitution for 3 months, for 4 months. Many of the students will do the same. I sincerely believe the common statement that winners do not do different things, they do the things differently. So you have to just adopt this method of guiding yourself to maintain a routine. And then you make a system. What kind of system? Integrate yourself with the class, integrate yourself with the question paper, integrate yourself with the syllabus, and do a precise mathematical, methodological preparation. Reading this book, reading that book, reading this material, that material, listening to him, listening to them, and asking many people. I went to a person and I asked him how to do this. He said that, and I followed his advice. So that is not going to work. You follow one advice. So develop your own system which suits you. But writing is a must. And I'll tell you how to pass this examination. If I said that this IS examination is examination of 200 questions in any paper, and I say you that IS examination is preparation of 400 pages in any optional, this is maximum. So 200 pages, 200 questions, 2 pages each, 2 pages answer of each. So you have 400 pages to read time and again, read it time and again, read it time and again. And whatever question will come, I tell you these 400 pages are going to work very beautifully. Of course, if it looks bulky, you can make synopsis of this 400 pages also, where you can write brief points and you can revise time and again these brief points. First of all, you see the question paper. If you do not have question paper, this is the question paper. It has all question papers. It has all questions of last so many years. Now, preamble, all questions are there. So if you solve all these 10 questions of preamble, I think preamble's study from different perspective is done. If the examiner is asking you an 11th question, this 10 perspectives which you have already read is going to help you to solve the 11th question. Similarly, in federalism, I find that there are 13 questions in this material. So if I have read these questions from 13 angle, then even if 14th, 15th, 16th, 17th, 18th, 19th, 20th question which will come up will obviously be guided and goaded by this 13, 14 questions perspective. This 13, 14 questions perspective will guide and goad them. So you should not worry at all. If you solve all these questions, your task is done. I tell you, there is a great saying which I have been saying to the students, that there may be many questions, but one answer. Many questions, but one answer. So just remember this. So maybe that 10 questions or 8 questions or 5 questions are of one type, similar type. So similar type question will have one answer. So if in fact this is not 150 or 200 questions, it may be hardly now 50 questions. Hardly, I said. Hardly 50 questions. So you should not be baffled and disturbed by this fact. Yes, past year question papers I am talking about. So if you do it, I think you will be wonderful. We will be doing wonderful work as far as preparation is concerned. Otherwise, you will go haywire. Your study will not be directed, dedicated, disciplined. If you want your study to be disciplined, directed, dedicated, my dear friend, this is the key. This is the key. And prepare synopsis of answer. Those who have good command over language, if they have synopsis, if they have points before them, they can write wonderful answer. And of course, along with this, just keep on updating yourself. You read newspaper constantly, whatever constitutional development comes there, whatever legal development comes there, now you can now see that very easily, very carefully. Now, as far as constitution only is concerned, we have just counted that there are 325 questions. But these 325 questions, will be brought within 50 questions, maybe 40 questions, maybe not beyond that. Not beyond that. All right. Now, so I said DRS and then I said my first advice was DRS, discipline, routine, system. Second advice is to all of you that start from the end. So DRS is start from the end. Start from the end means the question paper. Is this clear? So start from the question. No, never ever prepare from the book. Don't take a textbook and start reading. This is not a university learning, my dear friend. This is a competitive learning. So don't adopt textbook approach. It should be question paper approach. Then analyze the pattern of question. कैसे सवाल आते हैं? More theoretical, philosophical question. If you do not pick up the pattern of question, I tell you, you will be reading too much without having that perspective of IS examination, which is the missing link, I tell you. The missing link is there. Many people will read too much without this link, and then they will accuse the examiner, then they will accuse the examination, and then they will accuse the subject, and then in the end, if nobody is left, then they will accuse the teacher also. But this is not going to work, my dear friends, because you did not perform the task carefully. I can't tell this to all students preparing for IS, because those who have come to me, I can only share my idea with them only. So I said, analyze the pattern of question. More theoretical question, more case-based question, more philosophical question, more traditional question, more current question. So if you see the dynamics, if you see the matrix of question in constitution, you will find mix of it. Some questions are very dynamic, they are of current context. Like when this NJAC case came, National Judicial Appointment Commission, NJAC, then everybody knew that this will be question in exam, and this was the question in exam. So you have to understand this. Start from the end, analyze the pattern of question. Otherwise, you will be missing the link. Then, not only stop here. I will recommend you, my dear friends, when you analyze the pattern of question, you prepare the questions. Now, like preamble, we found 2 questions, 3 questions. Let us see it. Let us understand by example. I read question for you. It is written, the preamble to the Constitution set out the aims and aspirations of the people of India. Most of the questions of preamble cannot be answered after reading preamble because these are related to fundamental rights and DPSP. So little linkage is required. I'll tell you, but you have to start somewhere. Preamble to the Constitution set out the aims and aspirations of the people of India. To what extent have they been translated into the various provisions of the Constitution? Beautiful question. Constitution set out the aims and aspirations like justice, like liberty, like equality. You have written in this Constitution, promoting fraternity. How will you do it? What are the various provisions, methods, methodology, trick, technique? What is the way out? What is the path? This path is described in part 3 and part 4 of Constitution. Just look into that. It says preamble sets out the aims and aspirations. Yes. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of individual and the unity and the integrity of the nation. On this 26th day of November 1949, in this Constituent Assembly, we do hereby adopt, enact, and give to ourselves this Constitution. 84 words of Constitution eloquently clarifies the aims and aspirations. But these aims and aspirations are translated into various provisions. So when you read various provisions, then you can write better answer. And what is this various provision? I tell you, the various provisions are mostly contained in fundamental rights and DPSP. So when you see fundamental rights and DPSP, then you find that preamble has been guiding force. It has been a beacon light. It has been a beacon light, and it shows the path. And the government and the country has to tread the path prescribed in part 3 and part 4 of Constitution. If you write with this perspective, I tell you, you are going to get the best marks. But the problem is this, my dear friend, I tell you, whether your academic excellence takes you higher or whether your information deficit takes you lower, you are not matching the quality of question. Either you are high or you are low, and both are not going to work. You have to match. So this is very, very important, I tell you, my dear friend. Now then it says, then there are various other questions. With the help of relevant decisions, discuss the place of preamble. Place of preamble, whether preamble is part of Constitution, not part of Constitution, what kind of role, relevance, utility, use, importance preamble has. The place of preamble in Constitution. Of course, part or not part, this is one aspect. The second aspect is, what is its role, relevance, aim, importance, utility, use. If you write this, you create wonderful impact in the mind of the examiner. And if you write plainly, simply, place, tumne to place kabhi padha nahi, I have never read place of Constitution, place of preamble, then you are little bit confused. You have to behave like an officer. Mind you, my dear friend. You have to behave like an officer. It says, Constitution of India is first and foremost a social document, Granville Austin. Now, when he said social document, then he talked of social philosophy. We are talking of now social provisions in DPSP. We are talking of social things, now untouchability, etc., and fundamental rights. So, this is basically preamble question can be answered after reading of fundamental rights. But I just tell you how to analyze the pattern of question. These are all now you see philosophical, these are all philosophical constitutional questions which can be answered with the help of understanding of constitution. It is not information based. You tell me how many states are there in India, how many union territories are there in India, which judge said that, which judge said this, how many amendments have been carried out. These are preliminary questions. So I said preliminary perspective and men's mantra. These are two different things. Here question paper approach will work wonderfully, and you have to prepare the answers of different questions, different themes in constitution in 2 pages. If you can do it, I can tell you, you can complete syllabus within limited time. But if you can't do it, padate rao. You will keep on reading. And this is not going to give you any kind of yield, any kind of result. That is complete wastage of time. So many people you will see that they read little, but they have enough impact. See, in examination, can you write everything? You have limited space, limited time, limited questions. You have to produce limited information, but concrete one. So you prepare preamble in 2 pages, beautiful 2 pages. You prepare federalism in 2 pages with different perspectives. Of course, you should have all information. If you do not have information, it is not going to work. So I hope you understand what I said. Analyze the pattern of question. Then there are other kind of questions written here. Explain the form of government that Constitution of India has adopted, which has been subject of what reforms, if any, will you suggest? See, generally you will find in IS, I will give you a caution. Then when you see the old question, be careful that all questions are not relevant now. There are certain questions which are called stale questions. I have coined this term for yours convenience. Stale questions. That question was relevant at that point of time because that was a great issue at that point of time. But now no more it is an issue. It is not major concern right now. Everything is settled. But at that time it was not settled. So this was an important issue. Now NJAC has been asked in examination now. But NJAC, can it be asked after 10 years? The story will be far behind. This will be a story which will not be having any relevance at that point of time. So if you look back, that this was a question in that year 2017 or 18 paper, so it is going to come again. So this is not acceptable. So you have to be careful that certain questions are stale questions. Now federalism similarly, you will find that federalism has 13 questions, all questions on federalism. But now in these 13 questions, what I find, there is question whether India is federal or not. Then there is another question of different terminology, competitive federalism, cooperative federalism, quasi-federalism, traditional federalism, dogmatic to dynamic approach. These are all called playing with words. In international law, we use the word logomachi, dispute about words, not about the substance and content. So everybody knows what is Indian constitution, but different perspectives will help you understand better the nature of constitution. Why KCVR said that this is not purely federal? Why Supreme Court said sometimes it is federal, sometimes said non-federal? The same Supreme Court is saying two different things. And in recent times they said that this is pseudo-federation with amphibian character. In Kuldeep Nair versus Union of India, 2006 decision, the Supreme Court said it is pseudo-federation. Pseudo-federation. Looks like, but not. With amphibian character. It means it is changing. So now, why Supreme Court said this? What was the reason behind this? We'll try to understand. So I said, DRS system, start from the end, analyze the pattern of question, then prepare 2 pages answers. I tell you, I am giving you most important advice of all lectures today, of all relevant questions. I will help you here, don't worry. This is my job too. I will not help you in still question because that is not required. We'll be wasting our time, precious time. Sometimes you may say that this is a question. I'll tell you that this is not relevant now because the time has gone. Is this clear, my dear friend? Prepare 2 pages. Answers of all relevant questions. That we'll do in the class also, don't worry. Then number 5. Recent constitutional may give rise to questions. I'm not giving you too much advice because too much advice may not be followed by you. So I have given you very little advice. The first advice was DRS, discipline routine system. The second advice was start from the end. The third advice is analyze the question paper. Try to understand the pattern. That is very important. That is the missing link. Then prepare the answers. And then recent. So again I repeat, DRS, start from the end. Then I write it like this right now. Previous year questions. Then pattern. Then answer. And then development. These are 5 core strategy in your preparation. If you can do it, I don't think anybody can stop you from getting good marks in any subject whatsoever. Law also. But people will not do it. That is their problem. Now, some students think that I'll write too many cases and I'll get good marks. I tell you, this is a myth. Because I have many examples before me where a student has not got good marks by writing cases. No, it is not so. It is not correct. It is not going to help. Always writing too many cases is not going to help you, I tell you. And this is complication also. You may remember case in 1-2 topics, but can you remember cases in entire topic? Contract, tort, every subject, partnership. This is not required. Why are you making your task difficult? You should not make your task difficult, my dear friend. Let us make it easy. Now they are looking for officers. They are not looking for two persons who can be followers. No, no, no. You write good idea. You write beautiful words. You give good logic. You give good substance. Of course, whenever you remember a case, write that too. I'm not saying that you should not write. Though in questions they will invariably write. See, this is the examiner's pattern of asking question. Write your answer with the support of suitable cases and statutory provision. This is written generally in law questions, I tell you, but this is not required to be written. If you do not remember statutory provision, you don't worry. If you do not remember case, you should not worry at all. This is all myth. I tell you a story of a student who is from Uttar Pradesh. He had very humble background of law understanding and law learning. He was not from a great university. But another boy was from great university, the Central University. And he was brilliant too in his language. But both of them got almost similar marks. Fortunately, I tell you, the boy who was from humble background, who has good logic and good substance, and he's reading, but he does not remember cases and statutory provisions because he is not trained for that. He was from an ordinary humble background of Uttar Pradesh. May not be very good college, I will not remember exactly. But I tell you, he got exactly similar marks, just 2-3 marks now difference was there. But the first boy who was excellent in his academics, he got in one paper very good marks, in another paper he did not get good marks. But this boy got very good marks in both papers. So see, even if you excel in one paper, it may affect your potential in another paper if you too much concentrate on excelling. If you too much concentrate on cases, statutory provisions, it will drain your energy. Now, some students will come and they will ask you that how to score very good marks in a particular paper. If you want to score very good marks in a particular paper, it may be possible, but this is going to affect your marks in other papers. So, see, IAS exam is all about exam of average. You should not be too much, you should not be too low, you should be performing well and good. I hope you understood my idea. DRS PYQ pattern answer development. Development means recent development in legal field. Legal developments. Legal development. So DRS PYQ pattern answer. Now DRS is very important. Many people will not follow the system, will not make a routine. They will study anything, everything, many things, and they will be nowhere. Because they are wasting that so much time. They are interested in reading so many books. If you have time, you can read books, there is no doubt. Now see, like in federalism, I read 13 questions. In 13 questions, I can find hardly 3-4 questions. So this is how it goes. So you should not worry about that, my dear friend. So I think you are from law background, non-law background, you are from a great university, you are from an average university, all are good, you can excel. If you are from good background, you will have better chance, you will do it easier. And those who are from other background, they will take a little bit more. So everybody can do everything, that is what I firmly believe. Nothing great. Just follow the formula. If you follow the formula, I think you can do it. Is this clear? So let us start reading this constitution. Now, we'll be following all this. See, we are going to study this constitution. Now, in this constitution, my dear friend, there are 3 words which we generally use at the outset. Constitution, constitutional law, constitutionalism. Is this clear? Constitution, constitutional law, constitutionalism. And then there is constitutional convention also. Now let me explain these words at the outset, then we'll proceed further, because this may create sometimes some kind of problem. I have written in your material too. Now, constitution is that fundamental document. Constitution is that fundamental document. Must have seen Bare Act of Constitution, which describes the powers, the functions, the constitution, organization of different organs of government and its subsidiaries too. So, constitution is fundamental law of the land, which describes the power, the function, the organization of different institutions and its subsidiaries too. If you see Indian Constitution, it talks about the union executive, state executive, union legislature, state legislature, union judiciary, state judiciary. So it distributes power between them somehow. Legislature and executive power is divided. Judiciary is unified and integrated in India. And subsidiaries too. So there are many institutions, organizations which are mentioned in Constitution, like Finance Commission is there, Comptroller and Auditor General is there. So many institutions are there which are mentioned, and their power, functions, organization is also written in the Constitution. And this is the reason why Constitution is bulky also. So Constitution is that fundamental document which distributes power and functions and which describes the organizational setup of the central government and the state government and its subsidiaries too. And it also talks about the relationship between the government and the governed. See, it is written in your material, and this kind of question will not come in your exam. We will be writing those things very beautifully, carefully, which is answers of the questions. Rest is conceptual. If you can write, good. It's very good. You should write everything. But even if you are not able to write, you should not worry about that. Is this clear? So, constitution, constitutional law. Now, what is constitutional law, by the way? Constitutional law is basically, it is not only the constitutional document. It is not only the constitutional document. It is that constitutional document, and along with that, it also talks of the judicial decisions on the constitution, the conventions of the constitution. So constitutional law is a bigger term. It includes the document of constitution, its interpretation by the courts, the constitutional conventions to fill up the gaps here and there, constitutional conventions also, and then the report of committees and commissions also. So constitutional law is a wider expression, and your syllabus mentions constitutional law. So whenever you are asked a question, you have to be careful that if there is any report of committee conventions which is relevant, you should mention it. And that is what is current legal development. If some report of some commission and committee which is related to constitution, it's very rare, very rare. Now, constitutionalism. Constitutionalism is basically certain norms and principles which ensure limited government. Constitutionalism is a set of principles. Constitutionalism is set of norms and principles which ensures limited government. And constitutional conventions are those unwritten rules which are followed as customary practice to fill up the gaps of constitution here and there. For example, who will be the prime minister? It is nowhere written. But your convention says it is the leader of majority party or majority alliance. He will be that the prime minister, and he will be appointed by the president as prime minister. So I hope constitution is a fundamental document you understood. Law is wider term that I said. The constitutional document, the judicial interpretation, the conventions, and the report of committees and commissions. So many things. Constitutionalism is basically a set of norms and principles which ensure limited government, and constitutional conventions are unwritten rules, basically, which help us to fill up the gap here and there, because many things are not written in the constitution, and you may not know what will come up in future. And these conventions are basically established norms which have been followed, which have been in practice in your system for many years. And slowly and steadily, these unwritten rules sometimes are converted into written rules as well. Sometimes you amend constitution and you write that in that constitution also. Now, when we go to study this constitution, then first and foremost in our mind comes the basic introduction of this constitution. And who can give better introduction of constitution than the preamble itself? Preamble is the nutshell of constitution. It is key to open the mind of the makers of constitution. It is the very heart and soul of the constitution. It is the best pressy writing which I have ever read in my life. It contains the nutshell of entire constitution. And this is the reason I tell you, it was written towards the end. When the entire constitution was written, then preamble was written. The entire constitution underwent 3 reading and discussion. Similarly, preamble underwent 3 readings and discussion. So if you look from this perspective, you will have no iota of doubt in your mind that whether preamble should be part of constitution or not. It is the crux, it is the core. It tells you the core commitment of constitution. So how it cannot be part of constitution? Unbelievable, unacceptable. But we'll discuss that just now. Now, if you look to preamble, which was based on objective resolution moved by Pandit Jawaharlal Nehru in 1946, Pandit Jawaharlal Nehru moved objective resolution for framing of the constitution, and this is the basis of framing of constitution, and on that basis this preamble has been drafted. If you look to the preamble carefully, you find that the best way of understanding preamble and reading preamble and memorizing preamble is formula of 3 C's. In first part there is country, in the second part there is citizen, in third part there is constituent assembly. Now, as far as country is concerned, you said sovereign, socialist, secular, democratic, republic. As far as citizen, you said justice, social, economic, political. Just memorize this, is not nothing different. Liberty, thought, expression, belief, faith, and worship. Equality of status and opportunity. Constituent Assembly on this day of 26th November 1949, we do hereby adopt, enact, and give to ourselves this Constitution. So, in Constituent Assembly, 26th November 1949, we adopted, enacted, and gave to ourselves this Constitution. Now, see, in first part, we said 3 C's. C. Country, Citizen, Constituent Assembly. Then first what we said, we the people of India having solemnly resolved to constitute India into sovereign socialist sect. We the people of India having solemnly resolved to constitute India. So we constituted country. We constituted, this is present tense. Sovereign, socialist, secular, democratic republic. Citizen, what you are going to give? Future. Justice, liberty, equality. We will give you justice, social justice, economic justice, political justice, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity. We will give you future. And Constituent Assembly, we did it. This is the past. We did it. This is our resolution. We resolved. So this is the resolutionary part. This is declaratory. And in the middle we have this is promissory. We promised it. So resolutionary part, promissory part, and declaratory part. These are 3 parts. These are 3 tenses. This is how preamble should be read. My dear friends, I said we were talking of preamble. So in preamble we read about that, but you see the questions. The questions in preamble has been the basic question which I just told you. And the question is very basic one. And the question is whether preamble is part of constitution or not. First it was said that this is part of constitution, but then it was said that this is first it was said that preamble is not part of constitution, and then it was said part of constitution. So a question is asked generally, preamble is part of constitution or not, and then the second question is related to that question, that if preamble is part of constitution, can it be amended? Now you add further, whether preamble is basic structure or not, then the second question. If you say yes, preamble is part of basic structure, then the third question comes, that if it is part of basic structure, can it be amended further? If you say yes, then they will ask you question. Then why not this 42nd amendment? They said that this cannot be done because this is altering of basic structure, because you added certain words in preamble. So we'll be addressing that question as well. And then there are other questions which are very diverse kind of question, and which cannot be answered on the basis of preamble. Like preamble contains the basic aims and aspirations which have been translated into the various provisions of constitution. So now you have to look to various provisions. So there you are required to keep in mind, you are required to keep clarity in your mind, that in those kind of question where you are asking questions related to other themes, other topics, then you can answer it only on the basis of reading of those three things. That is preamble, and then DPSP, and then this fundamental right. Let us see the questions. I have seen it. I have told you a little bit. The one question was, एक तो क्वेश्चन पूछा, इट्स सेकुलरिज्म, नहीं, इसमें लिखा है सेकुलरिज्म इज नॉट ए क्वेश्चन इन प्रियम्बल, सेकुलरिज्म इज क्वेश्चन इन आर्टिकल 25. So we will be answering it in article 25, and I have written it in article 25 also, though secularism is in preamble, so we have inserted it here also. Then the second question which I have written in my previous year question papers, that is what is constitutionalism. So I just explained, this is general question. कॉन्स्टिट्यूशनल, अब देखो मैं क्वेश्चन का आंसर भी करूंगा, प्रेम्बल वाले जो सवाल होंगे प्रेम्बल में आंसर करूंगा. व्हाट इज कॉन्स्टिट्यूशनलिज्म? दिस इज फर्स्ट चैप्टर, so you have diverse introductory questions, so you should not be baffled and disturbed. You will have questions on preamble only in preamble. We'll be discussing like that, but this is first chapter, introductory chapter, so we have various terms here and there. So they have asked a question and I have inserted in this chapter. What is constitution? Explain the said concept both in its negative and positive aspects in the context of India's ties with constitutionalism and constitutional governance. This was 2014 question. At that time there might have been some kind of discussion on this point, and that is why this question, but let me address it right now. I said constitutionalism is basically a set of principles and norms which ensures limited government. For example, rule of law. Rule of law. Lex rex. Law is king. Earlier law was rex lex in past. Whatever king said, that is the law. Dinai lai akbar, whatever he said, that is the law. There was no one beyond the king, and the king was considered representative of God, and in many cases it was so. King was so kind and considerate, but in many cases it was not so. So this is one aspect of constitutionalism. The second aspect, separation of power. Now see, the moment you say law is king, so you are establishing rule of law. The moment you say it is rule of law, it means there is no one above law. Everybody is guided, goaded, controlled, commanded by law. Be it the prime minister, be it the peasant of the country. Everybody, be it the president, be it the constable. Everybody is guided and goaded by the law of the land. You cannot go beyond the law. If you indulge in corruption, even if you are prime minister, you see Prime Minister P.V. Narasimha Rao, he was tried at the time when he was sitting prime minister on the charges of corruption. On the charges of corruption. So this is what is the rule of law. This ensures limited government. Separation of power, where power is divided between three organs of the government: the parliament, the executive, the judiciary. The power is divided in India also. Judiciary will do judicial acts, parliament will do legislative acts, and executive will do executive act. Parliament can enact legislation, then executive will execute that legislation, and if there is any dispute, debate, constitutionality, legality issue, then it has to be decided by unbiased boundary commission like courts. It has to be decided by unbiased umpire which sits as court. So there is obviously constitutionalism in this country. Explain the said concept both in its negative and now see, this is the positive. Rule of law is positive, separation of power is positive, and many similar principles are there which ensures limited government. You can see even federalism ensures limited government in the sense that it divides power between the center and state. One prominent author of Constitution, Birch, he said, federal governments are weak governments. So they ensure that the power is divided between center and state, and both are given the task of acting for the people. In welfare countries, it is more important. The people's welfare is paramount consideration. Center and state both are required to do it. Negative and positive. Now, constitutionalism sometimes may result into legalism. Legalism is where you act according to law only. You emphasize on law, you overemphasize on law, and whatever law says that you do not go. So welfare takes the second seat and law takes the first row and the front seat. And that may create some kind of, now the issue of legality and the issue of welfare may have different directions sometimes. So that may be negative. See, if you understand, you can write. Separation of power ensures limited government. Law is king ensures limited government. It helps the people to command and control even the government, the powerful government. There will be question. Then it says, India strives with constitutionalism and constitutional governance. Obviously, the governance has been constitutional in India. We have not seen any usurpation by army officers as it is in Pakistan. So, constitutional governance has been the ethos and the culture of this country, and we have seen that the democracy has taken deep roots in India. So, we do not see in any near future that there will be something like which will go against the constitutional governance. Constitution is the core commitment of the country, and constitution is the guiding principle for both center and state. Everybody is controlled and commanded by constitution, be it the center, be it the state, be it the local government, be it the parliament, be it the judiciary. There will be some kind of now imbalance, some kind of like what happened recently in parliament was not very much appreciable. Even the officers, the position holders, they should behave properly. They should behave according to the rule as much as they can, because responsibility and accountability is the key concern of the people, and it should be key concern of the people sitting at the higher positions. So that is a challenge which will come up time and again, and this remains a relevant and a very important issue in our discussion right now. What do you understand by the constitutional conventions? I have just told you the conventions are those unwritten rules. Now when you ask me about conventions, I have written in your material conventions. I said conventions are unwritten rules. Lex non scripta. Lex non scripta. And these conventions are basically unwritten rules which have developed as practice and serve an important purpose to fill up the blanks in constitution here and there. Is this clear? Are they relevant in a country like India having a lengthy written constitution with preamble? They are very much relevant in country like India. Like I told you that now see, the prime minister will be the leader of majority party or majority alliance. Is it written anywhere in the constitution? Constitution only says that president will appoint prime minister, but it nowhere says that prime minister should be the leader of majority party or majority alliance. So how do you reach to this conclusion? So this is how we reach to this conclusion, that there is a convention, and the convention says that in democracy, where the people's popular choice must be given precedence and that must be respected in that particular sense, it is always the leader of majority party or majority alliance which will be given now privilege to become the prime minister, and the president will invite him to become the prime minister. Is this clear? So they are still relevant. Now, who will be the Chief Justice of India? This was not at all clear, but somehow a convention developed, a practice developed that the senior most judge of the Supreme Court will become the Chief Justice. And later on, see, the Supreme Court in a case reiterates this position and says, that yes, among the equally competent Supreme Court judges, the seniority has a priority. So the moment you said seniority has a priority, that convention which was established over a long period of time has got a constitutional now stamp from the Supreme Court also. So it shows the utility, the importance of the constitutional conventions. And these conventions have played major role. Explain the form of government that the Constitution of India has adopted and which has been the subject of what reforms if you... Now, this is not very relevant right now because nobody is looking for this, but just a brief idea to you. Now, see, this country, I tell you, there was a debate that in India, is there a kind of combination between presidential and parliamentary form of government? I tell you, very important, very relevant inquiry. Now, India is said to be committed to parliamentary form of democracy, of course. Now, if you see, now I give you the logic. The people of India elect the MPs, Lok Sabha, and the House of People, and the entire Council of Ministers is responsible to the House of People. Is it so? So, the people have elected the House of People, and the House of People will control this Council of Ministers. So, who is controlling? People of India is controlling. And then Council of Ministers has the head, that is Prime Minister, who takes all the decision. Now, so obviously, the Parliament controls the government. And the moment Parliament controls the government, it can be called parliamentary form of government. The decision of the government will be subjected to the scrutiny of Parliament. The day-to-day debate, the legislative process, the decision making, everything is subjected to scrutiny of Parliament. And scuttling the Parliament on any issue is not a fair working of the government. So taking another route and doing something without taking Parliament into confidence is not a fair idea. Parliament must be given precedence. This is what is the culture of India. This is what is the constitutional morality in India. We live up to that, and we should live up to that. Is this clear? So, of course, it is parliamentary form of government. But in parliamentary form of government, what happened earlier, I tell you, there was so much bickering and so much push and pull. And there were so many regional parties that there was always a coalition government. Khichdi Sarkar. There was a coalition government always. And where there was so many push and pull, the development suffers. The country suffers. And this is why this debate that whether we should be continuing with this form of government or we should adopt the two-party system. That was the debate of that particular point of time. Now that debate is no more there right now because there is one party which is ruling the country almost. There is National Democratic Alliance, but in NDA, this is the BJP which has got the majority. They have enough sufficient seat to rule the country even without support of other members. Even without support of other members. So in that sense, so this discussion is no more there. But I tell you one important information, my dear friend, that that in parliamentary system, the parliament controls the government, parliament controls the council, and council is the government which is responsible to the Lok Sabha, and Lok Sabha is part of parliament. So parliament is the controlling authority in everything. Everything is subjected to the scrutiny of parliament. But in India, if you see carefully, there is somehow some kind of trappings of presidential system also. How? So India is majorly a parliamentary form of government, but there is some trapping of presidential system also. How? If you compare India with America, in America president is elected, in India also president is elected. But here presidential election is indirect. It is by MPs and MLAs. There in America it is not so. In America president is people's choice. Here president is not people's choice. There the president has enormous power. In India also somehow president had got enormous power. Sometimes it can stop the government's decision making process also by exercising the veto, etc. And in case of government not enjoying majority, it can dismiss the prime minister. It can dismiss the prime minister. So president acquires importance in certain situation. It can dismiss the prime minister, it can dissolve the Lok Sabha, it can put veto on government's decision sometime. At least it can return the bill or decision for one time. That is what is the position after 42nd Amendment in 1976, Article 74. Article 74. 42nd Amendment, 1976, Article 74. Indira Gandhi made it very clear that the president cannot override the decision taken by the Council of Ministers and the Prime Minister. It can only return the bill or the decision for once. If it is given back to him, he has to sign it. See, there are other questions also. Justify the contemporary economic liberalization reforms on the basis of constitution. Now, constitution requires overall growth. Constitution requires that there should be egalitarian society. Constitution requires that there should be somehow welfare of the people of India. Constitution requires that all should be employed. Constitution requires that there should be growth and development. How will you ensure all this otherwise now if you do not go for economic liberalization? Liberalization is the key. You are inviting people, you are selling your stake, you are now promoting now somehow. So you have to look to that. And you will understand it even better when you read more and more constitution with us. First and foremost, a social document, granular. Now, social document, see the whole social philosophy of fundamental right and DPSP is written in the preamble also. It says liberty, social, justice, social. So we are talking of social justice, Article 14, 15, 16, 17, social justice. '38, social justice. We are talking of social and economic justice. We are talking of social provisions, socialistic provisions, where the people should be now and there should be redistribution of resources among the area and among the people. So what we are doing, we'll understand it when we read it. Just I'm giving you glimpse right now. Now, question number 4, rather question number 3 and question number 8 is same, only words are different. This is what is the key in your preparation. You have to understand. See, it has been impossible to resist the growth of convention of constitution in India, though constitution is a highly comprehensive document which presents every matter in utmost detail. So you are asking the same question in a different way. Is this clear? तो तुम्हें ये क्वेश्चन के अनुसार पढ़ना पड़ेगा. This is very, very important, I tell you. Secularism is an essential feature of constitution, though I said it is in Article 20, why this is the first question. Yes, secularism is an essential feature of constitution. SR Bombay versus SR Bombay case was what? SR Bombay case was based on this, and on that basis, the government of India dismissed many state governments on the ground that they have not been able to follow the secular ethos and culture of the country. They became rather party to one religious group or one group, and they acted something against the other group, the minority group, when they allowed the people to go for demolition of Babri Masjid. So they said that the secularism is basic structure of the constitution. And many governments were dismissed at that time. The other party governments were dismissed. Now, coming to the preamble part, question number 10, with the help of discuss the place of preamble. And question number 7, preamble to the constitution sets out the aims and aspirations, to what extent they have been translated into various provisions. So, various provisions, so you have to write how preambles, different themes have been translated into fundamental right and DPSP. That you will take little bit time. Like now, you wrote, to secure to its citizens justice social. So, social justice is there in 16, 17, 14, 15. So, you will write that. Article 38, 39, social justice is also there. So, you will write that. 46, that is, there is social justice. Educational and economic interest of weaker sections of the society will be taken care of. That is what is Article 46. So, many provisions. So, you will say this, that how this has been done. I hope you are getting my point, what I am trying to convey. This is beautiful discussion, by the way. But whether we are able to understand it or not. Now, you said justice, social, economic. So, how will you bring economic justice? So, economic equality, economic growth, economic, now 38 and 39 also, right to work in 41. Are you not talking of that? When you are talking of this one man, one vote, one person, one vote in Article 326, is it not political justice? The answer is yes. The Indian Constitution has sought to combine the presidential form with the parliamentary form. मैंने बता ही दिया. Now let us come to preamble in the end and let us do it. अब प्रियम्बल में क्या सवाल है वो तो आपने समझ ही लिया. प्रियम्बल के रोल क्या है, प्रियम्बल की यूटिलिटी क्या है. I have written in your material, so just read it. Those who have time, those who do not have time, they are not required to read even. You should not worry much. Just अब preamble क्या करता है? Preamble and so see, preamble is key to open the mind of the makers of constitution. Everybody knows this. Preamble is nutshell of entire constitution. Everybody knows this. Now, preamble has been written, I just said, towards the end of constitution, just to ensure that the preamble contains all themes and all things of this constitution, and so that anybody who wants to get any idea of constitution can get very easy idea of constitution by reading this preamble. So that is the basic purpose of this preamble. It is key to open the mind of the constitution makers. It is nutshell of the constitution. It is brief of entire constitution. So obviously various things are here which have been translated into details into various provisions of the constitution, no doubt about this. And various themes of preamble is written in that preamble, like sovereign. So what is sovereign? See, in your exam this may not be so relevant, but you should know little bit. Sovereign kaun hai? Who is sovereign? So sovereign is that who does not have any external control. Like India is sovereign. Now a question was raised, can it be said that India is sovereign? See, this is the world where every country is dependent on other countries. So a question arises theoretically that India is sovereign because India's decisions can be regulated, restricted, at least can be somehow impacted, affected by the neighbors or by its strategic partners. India cannot take a very independent decision all the time. Sometimes it will take decisions, but every time it cannot. Now, like this attack on base of some terrorist in Pakistan, India can take decision. But India, if it wants an out war with Pakistan, can it do? I think no, it cannot do it. So it has to be taken care of. So sovereign, socialist. Now see, capitalist and so capitalist where certain people are there and who control and command the economic resources of the country. They own mass. They own now production system. But in socialist country, it is just other way around. India is basically a different kind of socialism where we are not completely socialist, we are not completely capitalist. We have adopted some socialism which will help our people, but at the same time, we have not prevented the growth of private entrepreneurs. So we have adopted mixed economy, joint economy. It is a different kind of economic structure which we have adopted. Mixture of democracy and socialism. So here is democracy, here is independence, here is liberty, but not at the cost of any other thing. And along with that, there is socialism also. The government will control and command many things. See, government is losing its control and now government is setting its shares nowadays. So many people will raise question that when government is setting its share, it is losing its control everywhere, at least in business. Can it be said to be in true spirit socialist? So you have to give a very balanced opinion. Now, there is no fundamental change in the country, but of course, there are certain changes and which is required as per the need and necessity of the society and time. Just read it. There is so sovereign, socialist, secular, where everybody is independent about his own religion. India talks of Sarva Dharma Sambhava, We are secular in the sense that we treat all religions equally. See, Article 15 very clearly says that the state shall not discriminate against any citizen on the grounds of race, religion, caste, sex, or place of birth. So, India is not going to now discriminate against people of one religion and people of other religion, and there will be no preference to one and no secondary position to another. This is not the country. We are not theocratic state like Pakistan. Theocracy means where country has a specific religion, as it's like Pakistan is Islamic state, Bangladesh is Islamic state, but India is not a Hindu state. India is a secular state. So, sovereign, socialist, secular, democratic. Of course, we have representative, indirect democracy. We elect MPs and MPs will govern us. So, this is what is democracy. It is people of, government of the people, for the people and by the people. And republic, of course. Here is republicanism where the head of state is not hereditary. President is not hereditary. Republican system is that system where the head of a state is not hereditary. He is elected by the MPs and MLAs, indirectly by the people. And of course, to secure to its citizen justice, social, economic, political, liberty of thought, expression, belief, faith and worship. See, liberty of thought expression 19, 20, 21, 19 basically. And belief, faith and worship, that is 25. Belief, faith and worship, that is 25. Liberty and equality of status and opportunity. See, for equality of status, we have Article 14, 15, 16 also. And opportunity, 16 talks of opportunity. Equality of status and of opportunity. Then, equality of status and of opportunity. Then, and to promote among them all fraternity. Fraternity is basically feeling of brotherhood. Now see, we have single citizenship. Single citizenship is meant to promote this fraternity. You are Hindu, I am Muslim. You are Buddhist, I am Jain. You are Christian, I am Hindu. So, this feeling should not be. We are all Indian. We are one nation, one citizen. Beautiful idea. In this country, all are Indians. We may be Hindu, we may be Muslim, we may be Christian, we may be Sikh, we may be Jain, we may be Buddha, we may be Parsi, we may be Jew, but after all, we are all Indian. So this is what is feeling of brotherhood. हम सब भारतवासी एक हैं. Then what is written? Equality of status and promote among them all fraternity, assuring the unity and integrity. Unity is external unity. Integrity is that bond which should develop between us. Integrity, अखंडता, एकता और अखंडता. हम खंडित न हो आपस में. We should not be divided, partitioned within also. We should not behave like you are Bengali, I am Bihari, or you are Punjabi, I am Tamil. It should not be like that. It's really bad. It's really bad. This parochialism, this regionalism is now taking toll of India. So that should not happen. This is why it is required that there should be integrity. It should not be only unity, that India is united. We are 28 states and 8 union territories and we are united. No. It should be integrity also. Integrity, that internal bonding should be there. I hope you understand these words. If you are asked a question, you can answer it little bit. Now, coming to the question of preamble being part of constitution or not. Question बहुत trivial सा है, but फिर भी I said in Kesavananda Bharati. Rather, first it was that Riberu Bar Union, no? In Re-Berubari Union AIR 1960, Supreme Court 845. First in Re-Berubari Union AIR 1960, Re-Berubari Union. You must have heard the name of the case. Re-Berubari Union. देखो केस का नाम इंपॉर्टेंट नहीं है फिर भी AIR, दिस इज ऑल इंडिया रिपोर्टर. एवरी ईयर इन decisions of Supreme Court, High Court is published in All India Reporter. So this is All India Reporter of 1960. This is Supreme Court decision AIR 1960 Supreme Court page 845. So AIR जो बना होगा, whatever AIR is prepared in 845 page. So if in the first volume you find 500 pages, this will be available in second volume. And this is year number 1960. Every year there will be an AIR. And AIR will have several volumes because this cannot come in one volume. So All India Reporter, 1960 year Supreme Court, this is decision of Supreme Court, page 845 where it is reported, written. So Re-Berubari, Re means reference case, this is a reference case. Supreme Court is referred the cases, you know, under Article 143. So Re refers to reference case. Is this clear? Reference case, this is a reference case. So AIR 1960 Supreme Court 845, here in this case the Supreme Court said preamble is not part of Constitution. Preamble is not part of Constitution. Why Supreme Court said so? The reason is but obvious. Supreme Court said it because of the reason that generally preamble is not part of the act. Generally preamble is not part of the act. Preamble is only the prelude to the act. It tells you basically the object of the act, nothing beyond that. So in Re-Berubari Union, the Supreme Court said that this preamble is not part of the act, part of the Constitution, because preamble generally is not part of the act. Because preamble is written before the act is written. The object is written first and then the content of the various provisions of the act is written. So preamble is not considered part of different statute. But unfortunately, in this preamble, it was a different story. And that is how Keswananda Bharati versus State of Kerala. Keswananda Bharati versus State of Kerala. Keswananda Bharati एक party है. This is one party versus State of Kerala. This is another party. AIR 1973. So this is All India Reporter of 1973 where it is reported. Supreme Court 1461. Again, this is decision of Supreme Court. High Court cases are also reported. Page 1461. When you will open this page, you will find this case. Keswananda Bharati versus State of Kerala. In this case, in Keswananda Bharati versus State of Kerala, in this case, the Supreme Court said that preamble is part of Constitution. It is part of Constitution. Now, there is a question why Supreme Court changed its view after 13 years. So I tell you, this was due to the reason that an information was brought to the notice of Supreme Court vide volume 10, page 453 of Constitution Assembly Debates. Volume 10, page 453 of Constitution Assembly Debates. Volume 10, page 453. Now what happened in this case, Supreme Court accepted this view that the preamble was enacted and adopted towards the end, after whole Constitution was written. And it underwent 3 readings. It passed through similar process as the other part of Constitution. And so, The Supreme Court was convinced this time that no, preamble contains the all basic things of constitution. It was enacted in the same way. It was drafted towards the end. It was adopted in the same way. It was enacted in the same way. It underwent 3 readings, etc., etc. So it should be considered part of the constitution. I hope there should be no doubt. But I must mention that I just referred Constitution Assembly Debates, Volume 10, page 453. But let me tell you, Constitutional Assembly Debates is not a tool of interpretation. It is not an aid in interpretation. It is just an information. You may accept, you may reject. You may accept, you may reject. Supreme Court has accepted the thing quoted before the court because it was the truth. And Supreme Court was not made aware of this fact earlier. And that is why there was error on the part of the court also. But Constitution Assembly debates is not an aid in interpretation. It is not binding on you. You may accept, you may reject. That's your choice. Is this clear? Now, let us move further. Now, once we have accepted that preamble is part of Constitution, now the second question comes. Now, preamble contains the basics of Constitution, so it is basic structure. So, in Kesavananda Bharati, Supreme Court also said, yes, it contains the basic structure of Constitution. Preamble is nothing but amalgamation of basic structure of Constitution. Now, if it is basic structure, can we amend the preamble? Then on this point, I must tell you that there is a problem in taking away certain basic features of Constitution. If you want to add if you want to make it clear, if you want to make it better, there is no doubt there can be no inhibition, prohibition, limitation. And this is what we did by 42nd Amendment in 1976. You added, sir, include madams also, you added secular. You added socialist. India was not socialist before. India was not secular before. India was secular even before. But this addition makes it clear that we are emphasizing, asserting this in the very first line of Constitution. Sovereign, socialist, secular. Socialist, secular were added. And integrity. Yes, of course, there was some kind of tendency, fissiparous tendency, divisive tendency here and there. Just to check it, just to make it clear that though India is federal country, but India's core commitment to unity and integrity remains there. So integrity is a key concern of Constitution. And it should be there in the preamble of the Constitution. So we added it there. So there is no doubt you can add, insert. But of course, there may be some question when we delete, remove. Of course, if I talk of use and importance of preamble, the first use and importance I have already said time and again, it is key, it is nutshell, it is the brief, it is the best pressy writing. It declares the type of polity. ये democracy है, ये democracy है, ये republic country है. So it describes, it talks about liberal democracy also. Liberty is key, core, concern, commitment of Constitution. It also talks of the source of Constitution, the people of India. The people of India is the source of Constitution. And many more things. Is this all right? But I think for your men's examination, these two issues, whether preamble is part of Constitution or not, and Preamble contains the basic themes, and can it be amended or not, that is relevant. But you will learn more and more when you read fundamental right and when you read this federalism. Constitution, constitutional convention, constitutional law, that should be clear to your mind. Preamble can be amended, yes. बुक लिस्ट पे तो मैं नहीं बोलता ज़्यादा, मैं तो कहता हूँ पहले आप बेयर एक्ट को पढ़ो ध्यान से एंड यू रीड देयर मटेरियल फर्स्ट. As far as book is concerned, see, if you start reading books, maybe that you will be deviated. If you have lesser time, it may be counterproductive. But if you want to read the book, there are many B.N. Shukla's book, and this M.P. Jain is very good. Shorter M.P. Jain student edition is very good. V.N. Shukla is very good, edited by Professor M.P. Singh. Narendra Kumar's book is very good. So, the book has information, my dear friend, and ambition material is very good, sir. I think you should concentrate on suggestions which I give. No more deviations. You concentrate to the question, you concentrate on the discussion, you read your material carefully. First understand basic idea. अभी आप idea develop कर रहे हो. अब बेसिक स्ट्रक्चर डॉक्ट्रिन अभी नहीं जानना है भाई. अभी तो अमेंडमेंट, व्हेन विल डिस्कस अमेंडमेंट आई विल कम टू बेसिक स्ट्रक्चर. अभी तो प्रियम्बल की चर्चा कर रहे हो, तो डोंट ब्रिंग बेसिक स्ट्रक्चर. दिस इज अ separate discussion which will be taken care of in amendment. Don't worry. Any other question on preamble? We are talking of amendment. Amendment is a separate topic. We'll discuss amendment. Don't worry. बहुत अच्छे से पढ़ेंगे हम amendment. And I will request all of you, my dear friend, to go to Ambition's YouTube channel and watch IPC. IPC lecture is especially, I have written there, for IAS and judicial preparation, but that is basically meant for IAS students. So IPC के उस lecture में I have suggested the ways, the means and mechanism and little bit methodology which I was sharing even today. So just see IPC lecture. Now I will share the link in your group also. IPC lecture is there, which is very important. And in IS class I have given emergency lecture also. So you can see that with that as well. So thank you very much. I hope you enjoyed the class. Even if you did not, please say good. Be positive always. Positivity gives you enough energy. You can do it, you will do it, you must do it.